The chief instrument through which judicial activism has flourished in India is public interest litigation (PIL) or social action litigation (SAL). Hello friends, welcome back to the channel. The public interest litigation bill, it refers to litigation undertaken to secure public interest and demonstration the ability of justice to socially disadvantaged parties, and were introduced by Justice P. N. Bhagwati and Justice V. R. Krishna Iyer. It is a relaxation on the traditional rule of locus standi. Before 1980s, the judiciary and the Supreme Court of India entertained litigation only from parties affected directly or indirectly by the defendant. It heard and decided cases only under its original and appellate jurisdiction. However, the Supreme Court began permitting cases on the ground of public interest litigation, which means that even people who are not directly involved in the case may bring matter of public interest to the court. It is the court privilege to entertain the application for public interest litigation. One of the earliest public interest litigation was filed by G. Vasanta Pai, who filed a case in the Madras High Court against then the sitting Chief Justice of the Madras High Court, S. Ramachandra Iyer. After it was found the judge has forgotten his date of birth to avoid compulsory retirement at the age of 60, and his younger brother sent invitation to celebrate his 60th birthday, and Pai found evidence after photographing his original birth register which showed that real age, which was 64. Ramachandra Iyer resigned on the request from then Chief Justice of India, P.B. Gajendra Gadar, as the case would damage the judiciary, and he has resigned before the case came up from the hearing. This led the case to be dismissed as he has resigned. The concept of public interest litigation is suited to the principle enshrined in Article 39A of the Constitution of India to protest and deliver, promote social justice with the help of law. Before the 1980s, only the aggrieved parties could approach the court for justice. After the emergency era, the High Court reached out of the people and devised a mean of any person of the public or NGO approaching the court to seek legal remedy in case where public interest is at stake. Bhagwati and Justice V. R. Krishna Iyer were among the first judges to admit public interest litigations in court. Filing a public interest litigation is not as cumbersome as usual legal case. There have been instances when letter and telegram addressed to the court has been heard as public interest litigations.